Welcome back to the deep dive. Today we are taking a really focused, pretty technical look into the Manual of Patent Examining Procedure, the MPZP.
That guidebook for everyone in the patent world.
Exactly. And we're tackling Chapter 1100 that covers, well, quite a range. Statutory invention registrations, pre-grant publications, PGPubs, and even rules on third-party submissions.
That's a big chapter.
It is. Our mission today, cut through the legalese, the code sections. We want to get into the practical side, the how-to of managing your application's publication status. This is stuff where, if you miss a step, it can really cost you.
Absolutely right. Chapter 1100, it's fundamentally about when and how your invention becomes public before a patent is granted. And in patents, procedure's everything.
So the details matter.
Immensely. We're focusing today especially on the crucial admin side, the forms, the documentation for pre-grant publication. MPP, Section 1135, really lays this out. Get the forms wrong, get the procedure wrong, and you've got a problem. Compliance really lives or dies here.
Okay, let's unpack this then. Where should we start? Maybe with some of the recent changes. The USPTO seems to be streamlining things internally.
That's a good place to start. The MPEP reflects this internal evolution. Like, in MPP Section 1126, there's this subtle change in naming.
Subtle how?
Well, they used to refer specifically to the Office of Data Management Patent Publication Branch. A bit of a mouthful.
Yeah, definitely.
Now it's just Office.
Yeah.
Simple as that. Broader term.
Okay, seems minor. Bureaucratic tidying up. Or does it mean more?
I think it signals a more unified approach. Instead of siloing publication handling within one specific branch, calling it just the office suggests it's, a more integrated function. Communications are likely more centralized now.
So for the listener, maybe expect correspondence related to publication to just come from the office generally.
Pretty much. It streamlines things on their end and hopefully makes it clearer who's responsible overall.
And speaking of streamlining, there's the tech side too, the move to modern electronic systems. MPP Section 1128 talks about this, right?
Oh, absolutely. This is a big one. They're officially retiring references to the old image file wrapper system, the IFW.
Ah, the old scanned documents.
Exactly. That's being fully replaced in the guidance by Patent Center. And it's not just a name change for the website you log into, it's policy. Patent Center is the standard now for accessing published applications electronically.
And it's more than just viewing, isn't it? It's where you actually do things related to the application.
That's the key. It's an active platform. Which leads us to the next point, the formal framework for electronic submissions. That's in MPP Section 1130 and 1133.
Okay.
They've updated the name here, too. Used to be the EFS Web Legal Framework. Now it's the much broader legal framework for patent electronic system.
Again, signaling unification.
Precisely. It means that any electronic filing, whether through Patent Center or potentially future tools, falls under one single comprehensive legal standard. Less ambiguity, more consistency. Good for everyone, really.
Okay, so the systems are getting more unified. But what about when things go wrong? Human error happens. MPP Section 1130 has guidance on corrected publications, doesn't it? And it seems to draw a pretty sharp line.
It does. And this is critical for, due diligence. The MPP distinguishes clearly between errors the office made in publishing, which they might correct, and errors the applicant made.
Meaning?
Meaning not every mistake you spot in your PGPub is grounds for demanding a correction. The office isn't there to fix your typos or errors introduced in your original submission.
Can you give an example?
Yeah, a really specific one they highlight involves drawings. If the problem stems from an applicant's suggested drawing figure, maybe you submitted a figure with an error in it, the guidance is crystal clear, reinforced by an official notice just last year.
Don't ask for a correction.
Exactly. You should not file a request for corrected publication in that case. The office corrects its errors in the publication process, not your errors in the content submitted.
Wow. So the burden of accuracy before publication really rests squarely on the applicant.
Completely. It's a reminder. Check everything meticulously before it goes in, because fixing it after publication, if it was your mistake, might not be an option.
All right. That's a serious responsibility. Now let's talk about managing these high-stakes decisions, like deciding not to publish or abandoning an application to avoid publication. This is where those specific USPTO forms come in, right? Section 1135 territory.
Exactly. MPPP Section 1135 is basically the catalog of forms for managing publication status.
Yeah.
And the USPTO's philosophy here is really about eliminating ambiguity through standardization.
Standardized forms for standardized actions.
Precisely. When you're taking a big step, like expressly abandoning an application specifically to avoid it being published under 37 CFR 1.138C, you can't just write a letter saying we abandon.
You need the form.
You must use the specific form. And there are actually two, depending on the filing date. Form PTO AIA 24A for the newer AIA applications, and PTO's B24A for the older ones.
And using the wrong one would be bad.
It would definitely cause procedural problems. The reliance on these specific numbered forms ensures the procedural history is absolutely clear, auditable, and correct according to the rules. No room for interpretation.
Okay, so the forms create a clear trail for major status changes. What about requesting confidentiality in the first place?
There's a form for that too, naturally. If you want to request non-publication under 35 U.S.C. 122B, assuming you haven't filed abroad, you use Form PTOSB 35. You file it right when you file the application.
But what if you change your mind later? Or you do decide to file abroad?
Crucial point. If you initially requested non-publication, but then file a corresponding application in another country, you absolutely must notify the USPTO.
And rescind the non-publication request.
Yes, and guess what? There's a form for that. Form PTOSB 36. It actually does both jobs. It rescinds your previous non-publication request and serves as the official notice of foreign filing.
So one form handles the whole switch. What happens if you miss that? If you file abroad but forget to file Form SB 36?
That's a disaster waiting to happen. Your U.S. application can be held unintentionally abandoned.
Seriously? Just for missing that notification?
Yes, because the condition for non-publication, no foreign filing, is no longer met. But
Okay.
even for this specific type of abandonment, there's a procedural fix.
Another form.
You guessed it. If you need to petition to revive an application that was unintentionally abandoned because you missed notifying the USPTO about the foreign filing, you use Form PTOSB 64A.
Wow. So there's a form for the request, a form for rescinding it and notifying, and even a form for petitioning revival if you mess up the notification.
Exactly. It underscores how incredibly procedural this whole area is. Every step, every potential misstep, has a corresponding required form. Strict compliance is paramount.
This all ties back to confidentiality, doesn't it? Why are we so concerned about publication in the first place? Let's touch on the legal basis. 35 U.S.C. 122A. That's the core rule.
That's the baseline. It says patent applications are generally kept in confidence unless they're published under 122B. So unpublished applications are supposed to be secret.
Supposed to be, but there are exceptions.
Oh, yes. And here's where it gets really, really interesting, especially for portfolio management. We need to look at the regulation. 37 CFR 1.14a. It carves out a major exception for abandoned unpublished applications.
Okay, an application you thought was dead and buried and confidential because it never published?
Yep.
It can become public. How?
The trigger is reliance or identification. If that abandoned unpublished application gets identified, say, mentioned by its serial number, or is relied upon for priority or benefit in certain public documents.
Like what?
Specifically, a granted U.S. patent, a statutory invention registration, though those are rare now, a U.S. published application, a PGPub, or even a published international application. If your old abandoned application is mentioned in one of those,
Then the confidentiality is gone.
poof, the contents of that previously secret abandoned application can then be made available to the public by the USPTO upon request.
That is huge. It means you can inadvertently disclose an old application just by referencing it in a newer published one.
Exactly. Think about filing a continuation or a CIP. If you claim benefit to that abandoned parent application in the new application, and that new application publishes, you've potentially just made the entire file history of the abandoned parent public.
So confidentiality isn't just about the pending application. It's about managing the connections across your whole portfolio, even the abandoned parts.
You absolutely have to track those connections and understand the implications when you reference older, unpublished material.
Given these high-stakes abandonment, loss of confidentiality, it makes sense that the MPEP would be strict about who can even authorize these actions.
Very strict. Take express abandonment again, specifically abandoning without filing a continuing application under 37 CFR 1.138b.
Who can sign off on that?
The rule is explicit. Someone just acting in a representative capacity, like, say, a paralegal or someone not a registered attorney or agent, they cannot sign that request.
So it has to be the applicant themselves or their registered patent attorney or agent.
Correct. You need that proper legal standing to make such a final decision, to permanently pull an application before publication. It's a safeguard against unauthorized or mistaken abandonment.
Makes sense. Now, one more piece in Chapter 1100 is about third parties getting involved before grant. Pre-issuance submissions, right? MPP Section 1134.
Yes, this allows competitors, or anyone else really, to submit relevant prior art to the examiner concerning a pending application.
They can just dump documents.
Well, they submit the documents, but crucially, they also need to provide a concise explanation of the relevance. And the MPP guidance clarifies something important here.
Which is?
That concise explanation can include arguments against patentability.
Ah, so it's not just here's document X, it's here's document X and here's why it makes claim 3 unpatentable.
Exactly. It allows a third party to actually frame the argument for the examiner, to connect the dots between the submitted prior art and the claims. It turns it from a passive submission into a more active challenge.
A way for third parties to proactively try and shape the examination outcome.
Precisely. It's a key tool for monitoring competitors and potentially heading off problematic patents before the issue.
Okay, we've covered a lot of procedural ground here. Name changes, patent center, error correction, confidentiality exceptions, and the crucial role of all those forms in Section 1135. So what does this all mean for someone navigating the patent system?
Well, the big takeaway for you, the listener, is that these administrative details are not minor. The shift to unified systems like Patent Center, the clear line on correcting applicant errors, and especially the USPTO's strict reliance on specific numbered forms for every major action. It all demands careful attention. Using the right form like that PTO-AIA 24A versus the SB 24A for abandonment or the SB 36 for rescission isn't just paperwork. It's fundamental to maintaining compliance, managing confidentiality, and avoiding serious pitfalls like unintentional abandonment. Procedure is substance here.
A clear message. Get your admin right. Before we go, I want to extend a special thank you to Mike Shepard, the creative director who organized this entire audio series.
Hear, hear.
And now, the necessary disclaimer. This summary of the MPEP was generated using AI tools, including ChatGPT and Notebook LM, and may contain errors or omissions. It is provided for general educational and informational purposes only and is not legal advice or a substitute for formal instruction. For authoritative guidance, consult the official MPEP, a qualified instructor, or a registered patent practitioner.
Always consult the official source or a professional.
Absolutely. And finally, something for you to think about. We talked about how abandoned, unpublished applications can become public if they're relied upon in a later published filing. This raises a critical question, especially with complex patent families. How proactively do you need to monitor your own abandoned, unpublished files? If you file a continuation or divisional and claim priority, are you inadvertently making the parent application public? How much risk are you taking on by linking back to potentially sensitive, unpublished history? It's something to consider carefully in your portfolio strategy.